Morning, everybody. Or for those of you in California, it's probably 11 o'clock at night or something. My name is Mortimer Schnirkel, and I will introduce today's speaker, Alan Gassman. Alan Gassman is not very bright or very interesting, but he does show up at 11 o'clock on Saturdays to talk about different areas of estate planning and law. Fortunately, he will also be here today. Behind me to my left, relating to the theme of Florida, is one of Alan's favorite record albums, A1A by Jimmy Buffett. It includes the song The Great Filling Station Holdup and also My Whole World Lies Waiting Behind Door Number 3. So we hope that you buy the album, and I wish I got a royalty. In addition, we have a flamingo and a seal behind him for no apparent reason. We could not find the inflatable alligator, which is a good thing, or it probably would have eaten the flamingo. And of course, everyone knows why flamingos stand on one leg. It's so that they don't fall in the water. Okay, so regretfully now, I introduce to you Alan Gassman. Oh, thank you very much, Mortimer. That was very nice of you. I will turn the light on here, and we will get going. Please note my email address, agassman@gassmanpa.com. I do read my emails, contrary to popular belief, and I will answer them when I can. Oops, something weird just happened on my screen. Okay, there we go. At noon Eastern Standard Time, Rhett Schweitzer, a good friend of mine and a very, very bright physical therapist, has a doctorate in physical therapy, is going to talk about the intersection of physical therapy and yoga and what they don't know about each other. So I'm looking forward to that talk more than my own. I have a book on Amazon called Florida Law for Tax, Business, and Financial Planning Advisors. And if you will send me an email telling me 3 songs from one of my favorite Florida record albums, Tom Petty and the Heartbreakers, 1976, I will give you 1 song, and that is American Girl. This album was written in Gainesville, Florida, and recorded in LA. And what I thought was very interesting was that when Tom Petty and Mike Campbell and the whole band moved from Florida to LA, they took their trucks and they took their dogs, but they left their girlfriends behind. So this book is available on Amazon, but if you give me 3 songs from that Tom Petty and the Heartbreaker album in an email within the next hour, then I will send you a PDF of the book for free. And that's probably what it's worth. Next week, I will be talking about spousal limited access trusts. Now, this is not the limitations of your spouse, which I am sure are many, and I'm sure your spouse thinks you have a lot of limitations. I'm going to be talking about SLATs, spousal limited access trusts, and then at noon, Dr. Raul Rosden is going to demystify estate planning in the eyes of a science PhD. So don't miss that, and then Marty Shinkman and I will be here Saturday, April 9th, and he's going to talk about the human aspects of estate tax planning. He obviously has not seen my puppets. I'm going to talk on hot topics and best strategies for estate tax planning. So lots of things going on. By Monday, this webinar that you're listening to will be posted to our YouTube channel, and you can feel free to go there to see a lot of different webinars that we posted on a lot of different things. So please click on those webinars as often as you can, because we need the money. One of those webinars that you can look at, it was recorded with Jonathan Blotmacher. I call Jonathan America's greatest estate planner because he's had more impact positively on estate planning in the United States than any other person, and he's brilliant. So if you want to know what it takes to leave the orbit of a northern state to avoid income taxes and estate taxes there, and to move to Florida or Texas or Arizona or one of those other favorable jurisdictions, you definitely want to watch this YouTube video. And if you have any questions for Jonathan, you can send him an email and he's pretty good about answering his questions. He's just a very great and also charitable guy, by the way. All right, getting to the matter at hand, the first thing I want to mention is that if you move to Florida, before you move to Florida, I recommend that you watch this video on how to get an alligator off of your driveway, because if you move to Florida, there's no doubt that eventually you will have an alligator in your driveway. And I really liked the way that this police officer did it. You can just search Lutz, L-U-T-Z, alligator sheriff or something like that, and it will come right up, and you will enjoy it more than the alligator enjoyed it. That's for sure. By the way, on the alligators, don't get near a dog in the water. Alligators really like to eat dogs. Most of the time when people get bit by an alligator, there was a dog around. The alligator was hoping that the person was a dog. It had nothing to do with how this person looked in a swimsuit. It had to do with the odor of a dog. Page 13. Florida is about to have final passage of a new law that will enhance spousal limited access trusts that are formed in Florida. And I will cover this next Saturday. But the main message here is that if you form a spousal limited access trust in Florida for your spouse, and your spouse dies subsequent to the formation, and the spouse was the beneficiary of the trust until the spouse died, now the grantor can be the beneficiary and will not be treated as having been the contributor. So what that means is I can set up a spousal limited access trust for Marcia, and then if Marcia were to pass away, I could become the beneficiary of that trust, and it would still be out of my estate for estate tax purposes. That's one of the reasons that most of the slats that we form are in Nevada. That's one of the reasons, but not all of them. So I will talk about this in more detail. The other thing that Florida is changing in the next week or two is that trusts formed in Florida are going to be able to go for 1,000 years. I had a very large estate plan about 6 months ago, and the client told me to put it in South Dakota because he wanted to go for 1,000 years. He did not want to be limited to Florida's 360 years. Well, if he had waited till July 1st, we could have done it in Florida. So those are two major Florida law changes coming down the pike. The third major Florida law change is going to be in the area of alimony. So if you may pay or receive alimony, you might want to look at that legislation and decide whether to file your divorce before the new statute comes out. And I have pages and pages here showing you red line versions of these new laws and what they're about. And as soon as these laws pass, I'll be coming out with webinars to go over them in detail. So for those of you who are not from Florida, guess what? It's not all Miami and Orlando. There's also Tampa Bay with 3 million people. Tallahassee is the capital, 200,000 people, probably 20,000 of them bureaucrats, and probably 40,000 work for FSU, Florida State University. My guess, Jacksonville, 1.3 million. Pensacola, where the naval base is, 356,000. So you don't have to move to Miami and Fort Lauderdale and Boca Raton. Historically, people from the Northeast have come down I-95, and their friends come down I-95, and this started in the 1940s or the 1950s, coming down the East Coast. But people here historically who came from Ohio, Michigan, other Midwestern states came down I-75, and many of them landed in Tampa. So in Tampa, you're going to have a more Midwestern feel, and on the East Coast, you're going to have a more Northeastern feel, and that's how it happened. And by the way, when you're visiting Florida or when you tell your relatives to visit, they don't have to fly into Jacksonville, Orlando, Tampa, Miami, and rent cars. If you go through Atlanta, you'll find flights to many more smaller cities. So you'll have less rent-a-cars going on. And the Atlanta airport is a fantastic airport. I've never had a problem there. I've been through that airport at least 100 times. It's never taken me more than 12 minutes to get from any one connection there to the other. So again, if you want to visit Florida and you're visiting a client who's in somewhere in the middle of the state, go ahead and find a regional airport and you may have a better experience. As you will learn if you watch Jonathan Blotmacher's talk with me, the only thing you need to do to become a Floridian is show up and intend to live here. And you are a Floridian the minute you get here with your suitcase in hand. So, or maybe your credit card and you go and buy clothes. But in any event, you will go ahead and pay to have your car tags converted to Florida. You'll get your Florida driver's license. You'll tell everyone you moved to Florida, and you'll physically move to Florida. Move your dog here. That's a big part of the test. And then when you buy a property here, you can fill out an affidavit of homestead and get the Florida homestead exemption that I will be discussing. So Florida is very easy to become a resident. The question is, did you really leave New York? Did you really leave New Jersey? Did you really leave Connecticut? If you still have your house up there and you're visiting 5 months a year, then they do not believe that you totally abandoned that jurisdiction. So some of our clients from New York, we say, sell that house in New York, buy one in New Jersey to visit New Jersey 5 months a year. Don't go back to New York except maybe during the day to babysit the grandchild that's right over the state lines. But better yet, move the kids down here so you don't have to worry about your grandchildren up there. It's better if they're down here. Just write a big check and get them down here. Now, I've got a Florida compliance calendar for you, and hurricane season is June 1st through November 30. There's always a lot of good deals that you can send your mother-in-law or father-in-law on a cruise during the hurricane season. If they'll probably either have a good time or not come back, whichever you prefer. Then Fantasy Fest in Key West, if you ever want to paint yourself naked and run down the street, that would be in October of 2022. Tom Petty's birthday, October 20, 2022. And the release date of the A1A album, December 1, 1974. Hanukkah starts December 18th, if you didn't know. And our property tax filing deadline, pay it by November 30 and get a 4% discount on your property taxes. But to get the homestead exemption, you must live on the property, physically sleep there at least New Year's Eve, and then apply for the homestead exemption by March 31st of the next year. And now you can do that online. It used to be that you had to physically go there. Your vehicle tag renews on the owner's birthday. And if you forget, it is a felony. You could actually go to jail for a year for driving without a proper tag. So don't forget that. Or the Gasparilla Pirate Festival in Tampa on January 28th, or Bike Week in Daytona on March 3rd. So lots of things going on in Florida. A lot of the attendees are lawyers from outside of Florida. You do not have to be a member of the Florida Bar to practice law in Florida, with certain, of course, rules. As long as you do not establish an office or a regular presence in Florida, or hold yourself out to the public that you're a Florida lawyer, or appear in court without specific pro hac vice, they call it, consent from the judge, you're okay if you have clients in Florida who have called you because they know of your New York practice. And you're even okay practicing in the state of Florida as long as you follow these rules. We have recent opinions coming out during the COVID reign that it's okay if you're physically in Florida, you're barred in New Jersey, and you're doing work for your New Jersey clients from your home in Florida. That is now fine, and you can call the Florida Bar hotline and they will give you guidance. And the Florida Bar hotline is very, very good. They're very friendly, and they know their stuff. So already on page 69. Oh, thank you. Wildflowers. I didn't know that was one of the songs on that album. I thought that was a different album. Anyway, page 69. Florida has no individual tax, trust tax, or S corporation tax, or even reporting. So you can come down to Florida, buy a very profitable business, buy real estate, sell it, as long as it's in an S corporation or your personal name or the name of a entity taxed as a partnership or a disregarded LLC. No tax filing except for sales taxes, and no taxes imposed on Floridians or people from outside of Florida. We do tax C corporations at a 5.5% rate, but remember that's tax deductible. So most of our clients are in S corporations because they don't want to pay that federal tax. Number three, of course, like all other states, we have unemployment taxes, we have workers' compensation taxes. We have sales tax on rent, which most states don't have, but we have a sales tax on rent that typically is about 6.4%. We are not a community property state. I'll talk a little bit more about that later, but we do have something now beginning last year called a community property trust. Another key thing about Florida that we have that most states don't have is we have pure and complete protection and classification as tenants by the entireties under the law of tenancy by the entireties. When Florida became a state in the 1800s, our legislature immediately adopted the common law of England, July 4th, 1776, so that Florida's common law would run parallel with the common law of the 13 original colonies. And in 1776, the British common law had tenancy by the entireties. And what is tenancy by the entireties? It has nothing to do with the state of Tennessee or Tennessee Tuxedo, who was one of my favorite cartoon characters. Tenancy by the entireties was invented in England. Women were not allowed to own property, but fathers wanted to give a dowry in a way that would allow their daughter not to lose the ownership of the dowry. So what they did was they invented an artificial person called tenancy by the entireties, which was the husband and the wife together. And under the law of tenancy by the entireties, it would take the signatures of both people to divest the property, and a creditor of one person would not be able to touch the tenancy by the entireties property. And that's why it's so popular in Florida. So if Marcia and I have $1 million in a bank account, then if you get a judgment against me, you can't touch it. You would have to have a judgment against both of us. Florida recognizes tenancy by the entireties for almost any kind of asset, but you have to be careful because if you open an account outside of Florida in a state that doesn't recognize tenancy by the entireties, then according to at least one court case that I'm aware of, it will not qualify. And many institutions such as USAA indicate right in their account agreement that it will not qualify as tenancy by the entireties. So that's something important to know about Florida. And there's a lot of exceptions and traps for tenancy by the entireties. In fact, most clients who come to us with several accounts believe that they are tenancy by the entireties accounts, but they're not. And if it's not a proper tenancy by the entireties account, you cannot fix it. You have to start a new one and move the money or the assets from the old one into the new one. So those of you who are doing estate planning for Floridians, you want to be very careful about tenancy by the entireties. Now, page 76 was my 2-minute explanation exercise when I took the Dale Carnegie course about 15 years ago. And when you take that course, you have to give at least 2 speeches every night. And this one was explain an area of law in 2 minutes or less. So it's exactly 11:20. Let's see how I do. Florida has historically and consistently provided significant creditor protection for Florida residents. The first one on the top left-hand side is our Florida Constitution. And when Florida became a state, the first thing they did was say, move here and you will get 40 free acres of homestead and no creditor will be able to touch it. So if you are owing a lot of money to people up in those original 13 colonies, come down to Florida and we'll give you 40 acres that no one can touch because we need you down here. And it's unlimited value, up to half an acre within the city limits, but up to 160 acres outside of the city limits. And Florida's fraudulent transfer statute, which would allow a creditor to set aside a last-minute transfer into a creditor-protected asset, does not apply against homestead. So in the Havoco case, Mr. Havoco got a $13 million judgment against him. The day after the arbitration decision, moved to Florida, Destin, Florida, which is very close to where O.J. Simpson lives. They are neighbors, I think. And the court said, our Florida Supreme Court said, no, you can't touch it. What else is protected in Florida? Unlimited value, IRA pension plan, cash value of life insurance, 401k plan, tenancy by the entireties, college savings plans, annuity contracts, wages of the head of household for up to 6 months if they're supporting somebody, and 2 minutes are almost up. What do you call an asset that a creditor can't touch? An exempt asset. And Florida also has charging order as an exclusive remedy. So my 2 minutes are up. I have to go to the next slide. I have an asset protection checklist. I have a CPA's checklist for Florida creditor protection. I give a lot of talks on Florida creditor protection. I even maintain a book on it. Oh, I have it here. Gassman and Markham on Florida and federal asset protection law. So it's a big thing here in Florida. All right. What do you do if your client has an acre in Florida and they want to protect it from creditors? Well, we carve up the acre to half an acre of the home and the waterfront, the rest of the acreage into a family limited liability company, and we have an easement that allows only the homestead property to drive across the non-homestead property, so the creditor won't want it because somebody gets to drive across it. All right, so that's a lot about homestead. Let's talk about homestead tax planning. Florida has a wonderful, wonderful state property tax exemption for homestead. Homestead tax, the property tax is usually at just under 2% of the value of the property. Once you homestead the property appraiser is not permitted to raise the tax assessor value by more than 3% a year or consumer price index, whichever is less. So many people here have $3 and $5 million homes, and they're paying property tax on $300,000 to $400,000 because they bought the home for $150,000. So that is the Florida homestead tax and why it's so important. Now, those of you who are estate planners and estate tax planners, I will just let you know that you don't have to own the homestead to have it protected. You could be leasing it under a 99-year lease, or you could be the beneficiary of a trust that holds the homestead. And the property appraisers here in Florida, most of them are very generous with their time and their decisions. If you send them a copy of a trust or a copy of a lease, well before the end of the year, they'll be glad to tell you what to tweak or what to change so that they'll recognize that homestead exemption. So that's separate and apart from the creditor protection. In Florida, we also have green belting. So when you drive around Florida and you see little cows here and little cows there, usually they're allowed to, the cow owner uses the property for free, The property owner just needs the cows there to keep the property tax at near zero. So that is called green belting. Now, we also have a 10% cap for all non-homestead real estate. And this is really important now. So let's say your client bought a house for $500,000 in 2019. That house could easily be worth $1 million now, especially if it's anywhere near the water. So now your client comes to you and says, oh, I've just learned how ridiculous it is that I have this property in my name and I'm renting it. I'll put it in an LLC. And you go, great, here's an LLC, here's a deed. Oops, you lost the 10% cap. So how does the 10% cap work? Well, the client paid $500 for the house in 2019. In 2020, it went up to $700,000 in value, but the taxes could only go up to $550. Then in 2021, it went up to $900 in value, but the tax could only go up to 110% of $550, which is what, about $660. Then the next year it went up, 2022, it's now at $1.2 million in value, but the tax value can only go up to 110% of $660. And then it will continue to ratchet up. But if you put it in an LLC, or for commercial property, even if you transfer it between spouses, or if it's in an LLC, if you transfer more than 50% of the LLC, you're supposed to report that to the property appraiser, unless you're a publicly traded company, so that they can increase your taxes. So that's going to be an alligator. That's going to bite a lot of people. Speaking of alligators, I want to show you my favorite alligator picture. I went out in an airboat with a friend of mine about 10 years ago when I had more hair, and he used a flashlight. And when you do the flashlight, the alligators don't move. So then he rowed the boat to where the alligator was not moving. He reached his hand without a glove into the water, grabbed the alligator by the neck, and closed its mouth, and then he handed it to me. And as you can see, I'm holding the alligator's mouth closed. The thing about an alligator's mouth is that they have very weak muscles. You could take a 10-foot alligator and hold its mouth closed. It would never be able to open. But once they open it, when they close it, your hand or arm is gone. So I don't recommend that you do what I did. Instead, just use Photoshop and insert your picture over my picture. And that is and by the way, if you've ever tamed a snake, alligators work the same way. Once you handle them for a while, they do get tamed, almost like a dog, and you can hold them until you throw them back in the water. And of course, all of this is probably a felony, so I deny that I ever actually did it. All right, so I've got a lot of things here now. For homestead confidentiality, clients don't want everyone to know where their homestead is, especially doctors, psychologists, athletes, high-profile people. So what you can do is form a revocable land trust, a joint revocable land trust, which in my opinion can be a TBE asset, and then have the trustee of that land trust be an out-of-state LLC, because Delaware, Wyoming, Colorado, they don't reveal who the manager of an LLC is or who the owner of an LLC is. So only the title company and your hairdresser will know. So you title the homestead into the revocable trust at the closing when you acquire the property, and then the only thing that people see on the property appraiser website is the name of the LLC. And then you talk to your county property appraiser, and most of them, almost all of them, will keep your client's personal name off of the property appraiser website, even though they'll recognize the homestead. Now, there's a couple of counties where you have to do a little trick, and that is they insist that there be like a 21 or 25 character line that gives the name of the recipient of the homestead. And they told me it has to be a person, and my client got upset. So the person is Alan Gassman as attorney in fact for Charles Smith. So the only thing shows up is Alan Gassman as attorney in fact, and it doesn't show the name Charles Smith. So if you think I own a home in South Florida, guess what? I don't. I only wish I did. Okay, so that would be a way to provide confidentiality for a single client as well. But people think that land trusts avoid tax. They don't. People think that land trusts somehow limit liability. I have never found any support for that proposition. I want to mention in Florida that we have something that London Baines Johnson used in the 1960s, and that is the ladybird deed. He was the president of our country, and even though his wife's name was Ladybird, they were from Texas. And in Texas, women always have two names. And I guess her name was, of course, Lady Bird. She was a very lovely lady. But President Johnson owned the ranch land, did not want her to have it until he died. So he signed a deed which says, I hereby transfer this property to Lady Bird at the moment of my death, and until then I can revoke this trust. And we call this an enhanced life estate deed, also known as a ladybird deed. So as opposed to putting my homestead in a revocable trust, which might cause loss or doubt as to the creditor protection of the homestead, I can own my home and simply have a ladybird deed, which then delivers it to the revocable trust. So the ladybird deed in Florida, very popular. London Johnson, not as popular anymore. In Florida, if you are doing estate tax planning, the qualified personal residence trust works well. There's not going to be a stamp tax putting your property into a qualified personal residence trust. During the possessory period of the trust, you still get to keep your homestead. And then at the end of the possessory period, when the client has to start paying rent, you sign a 99-year lease of the property. So just for those of you who do estate tax planning, the Cuperts work well. We have a video on the YouTube channel on Cuperts that my partner, Denicolo, recorded recently, and I thought it was pretty good. I especially like the fact that I didn't have to record it. He handled it, and he did a nice job. We have strange and archaic rules on the disposition of a homestead. This is in our Constitution, and there's basically nothing we can do about it or nothing that we have done about it. If I die with sole ownership of a homestead, and I have a minor child, let's say she's 17, and I have no wife and 10 other children, then who are adults, on my death, the property immediately vests 1/10 each in the names of all my children, just because I have a minor child. It doesn't matter what my will says. It doesn't matter what my revocable trust says. It vests in the child. And if I'm married and the property is in my name only, and I have a minor child, it vests at the moment of my death. My spouse gets her choice of a life estate or a remainder interest. And my children get what's left, a vested remainder interest, where they have to wait for my wife to pass away before they get it, or they share 50% ownership. So most of us have our homes jointly as tenants by the entireties with right of survivorship with our spouse. Otherwise, if I'm single or I'm in a second marriage, I may put my homestead in an LLC and then lease it on a 99-year lease so that when I die, that homestead will pass, hopefully, by my will or trust or by a pay on death designation under the LLC, which we have in Florida, but not a life estate in a spouse, remainder interest in a 17-year-old who then has that money when they turn 18, to the extent that the guardian hasn't spent it. So please do be careful with Florida homesteads, and that's why a lot of clients keep big mortgages on their homesteads, So at least most of their wealth would go in the way their will or trust provides. Now, if you're going to send your child down to Florida to go to the University of Florida in Gainesville, or a Florida State University in Tallahassee, or University of South Florida in Tampa, and you want to buy a house or a condominium for the child, consider setting up what we call a homestead irrevocable trust, known to many of you as a Section 678 trust. We'll make Code Section 678 the code section of the day here for this presentation. So I put this property in a trust. My daughter is the trustee. The trust is for the benefit of my daughter and my spouse and our descendants. My daughter is only one of the beneficiaries. I put $100,000 into that trust. I give my daughter 30 days to withdraw it and inform her that if she does withdraw it, I will disown her. If she doesn't withdraw it, the trust now buys a condominium for $100,000. Yes, it's a pretty small one, but it is a condominium. My daughter lives there. Daughter has the property tax on her income tax return, not mine. And the interest on the mortgage, my daughter gets the deduction, not me, because the trust is disregarded. Now the condo sells for $150,000 when my daughter graduates. No income tax because it's considered to be hers, and we can use the $250,000 exclusion. So the condo gets sold for $150,000, and then the money is spent on my spouse, who is a beneficiary of this Section 678 trust, as my daughter continues to pay income tax on the trust, or perhaps a trustee appoints the assets back to my spouse. So even if this isn't needed for creditor protection, for estate tax purposes, it serves an income tax purpose, and it also keeps me and my spouse protected from creditors if my daughter throws some really good parties and gets a lawsuit against her and the homeowner. So that is the Section 678 trust. I have a little YouTube video where I explain that to my granddaughter, Ava, and you can Google Gassman 678 trust and see that YouTube video. And if you watch it 1,000 times, I think I get something like 25 to 30 cents in the mail from YouTube. All right. So we do have a court of decision, the Bleckman case, which says that you can have a limited liability company provide in the operating agreement, on my death, my ownership will go to Marcia. So then on death, it goes automatically. It's like a pay on death designation of a limited liability company. And you have that in New Jersey as well. So if you live in New Jersey and Florida, you are doubly fortunate. Now, this would apply to a New Jersey or a Florida LLC. Would this apply to an Iowa LLC? And I think some of you know why I'm using Iowa as an example. There was a 2019 case where a Florida married couple set up and owned an Iowa LLC. Know why? But in any event, the husband got sued, and they titled the ownership of the LLC into tenancy by the entireties. So what law applied? If Florida law applied, then the creditors could not reach the husband's half of ownership. If Iowa law applied, then the creditor could get what's called a charging order against the husband's half ownership in the LLC. Well, the Iowa Supreme Court, in the first case of this question that I have ever seen determined, and I have researched this for many hours in the past for other clients, the Iowa Supreme Court, one of the top 50 Supreme Courts in the country, said that Iowa law applied. So when I have a Florida married couple and they want to set up an LLC, I'm going to use Florida, Delaware, or Wyoming, because those are the 3 states that allow tenancy by the entireties in a pure manner. Other states, not so much, like Tennessee has tenancy by the entirety, and it allows the creditor to get a lien against the ownership interest of the debtor spouse and to receive the asset if the other spouse dies first. If the debtor spouse dies first, the creditor doesn't get anything. So you've got to die to avoid the creditor, which is not very popular. So maybe that was off on a tangent, just like the discussion of Tennessee tuxedo. Florida, Wyoming, and Delaware, and also many other states, but not California and not Colorado, also provide in their law that the sole remedy of a judgment creditor against an individual who has ownership, part ownership in an LLC, is a charging order. Oh my gosh, that was a long sentence. What did I say? Okay, I own 85% of an LLC. My daughter owns 15%. The LLC has $1 million cash in it. You get a judgment against me. Can't reach into the LLC. You can't take my ownership. You only get a charging order, which is an order from the court, which says if and when that LLC ever makes a distribution, you've got to give the money to the creditor. 85% of any distribution goes to the creditor. Now, there was a recent case in Utah where a Nevada LLC owned 44%, I think 44%, by a debtor, 44% by a friend of his, and then the rest by their children, allowed the friend to get a lot of money out without making a pro rata distribution to the debtor, even though the operating agreement said they had to. In addition, the Wells Fargo loaned money to the debtor. I don't know why they would have, using the assets of the LLC as collateral with the permission of the LLC. Well, the creditor, which happened to be Sarah Lee, you know, everybody doesn't like something, but nobody doesn't like a charging order from Sarah Lee. That's what it came out to be. So Sarah Lee suing this guy over some sort of donut dispute or something like that, Danish dispute, to the court and said, Judge, they should have made a distribution instead of borrowing from Wells Fargo, and they should have made a distribution to him at the same time they made a distribution to the friend. And the judge said, you were right. And the judge allowed the creditor to reach into this LLC and pull out over $1 million. But if they had done this properly, the charging order, I think, would have stood. So that's a little bit about charging orders. All right. So first of all, let me go ahead and answer some questions here. Some of you may need a mental break anyway. Okay, you're right. Wildflowers was, I believe, the last Tom Petty album. Okay, from Michael, who always asks me a lot of good questions and usually pays me to answer them. What if your New York house is not in the individual's name, but in the name of an LLC or something like that, I believe is what he meant. That may help. That may help. But when New York sees that you're physically sleeping in New York for a few nights a year, I think you're going to have trouble. I think you should do your sleeping in New Jersey or Connecticut. Okay. Can a Florida resident who owns New York real estate give it away within 3 years of death and not be subject to clawback of the real estate for the New York estate tax? I think so. I know that New York has no gift tax, so you can give it away. But you know what, Abigail? I'm sure if you Google New York gift tax, gift clawback 3 years, I think you'll find that there's no clawback there. Okay, does charging order apply to a single member LLC? That's from Stewart. And that's Stewart. The guy's name is Stewart, not Stewart, Florida. So now you know the name of another city in Florida. There's another city in Florida called Homestead, And then one of my favorites is Yeehaw Junction. All right, but anyway, Stewart says, does a charging order apply to a single member LLC? The answer is no. But first, the creditor has to show the court that there are no other assets that the creditor can reach. Now, a charging order can be the sole remedy for an LLC in Nevis if you set up the LLC in Nevis. So some of our clients do set up Nevis LLCs instead of Florida LLCs for three reasons. Number one, I can charge the client more. That makes it worthwhile. Number two, you can have charging order protection for a single member LLC, even though we always have two members in case Florida law applies. And number three, if they really want to get the assets out of Nevis owned by that trust, they have to go to Nevis and file a suit. And then you have to, before you can file the suit, you have to put $100,000 in the Nevis court registry, which is why, to my knowledge, nobody has ever challenged a Nevis LLC or a Nevis trust. Okay, so thanks for that answer. Okay, how do you prove you no longer live in Oregon if you keep a place there? Well, don't go there, I guess, and your cell phone knows where you are now, and your Find My phone knows where you are. So just don't go back to Oregon, ever. All right. By the way, Oregon has a very good, or let's say effective, legal suicide statute, the only one I'm aware of in the entire world. And that might be the reason for some people to become residents of Oregon, but then you have to pay Oregon income tax. And so then nothing's more sure than death and taxes in Oregon, I guess. Okay, ladybird deed avoids homestead device restrictions, right? Richard, I don't think it does. I think that would be too easy and too good to be true. So I think you still have those issues. All right, Abigail says, if wife dies and leaves a home to spouse, does it vest immediately or does the estate have to transfer it? That's a really good question. The spouse can elect, so I don't think it vests immediately. If you have a minor child, I think it vests immediately. If you don't have a minor child, I think it doesn't vest until the spouse makes her election or his election to have, well, actually, I think the life estate vests on death. The rest of it would come by estate. But sorry, I'm not so clear on that. All right. Nancy, did you say the person who creates the ladybird deed should file a gift tax return? No, it's a revocable gift. So you're fine with that. Finally, Stephen, for a multiple member Florida LLC, what's the minimum percentage? Well, Tom Wells, who's a well-respected lawyer, article saying it should be at least 5%. And I called him and I said, why did you say at least 5%? And he said, well, it needs to be material. And I said, well, if there's $1 million in that LLC, 5% is $50,000. Last time I checked, $50,000 was pretty material. So there's no Florida court decision on this. There's not in the statute, but you can go to the Albrecht case, which was a bankruptcy court case, and the judge said as long as the other owner has a peppercorn of ownership. Now, this judge was up in the Northwest. I'm not even sure what a peppercorn is, but it would need to be, I would say, at least 0.5%. Now, we go further, and we will divide the LLC into voting and non-voting member interests. So I will form the LLC with 0.5% voting member, 1% voting members and 99% non-voting member interests. And then I will transfer at least 0.5% ownership in the form of a voting member interest to a relative, a friend, or an irrevocable trust for the children. And I consider that to be material enough. But just to go to the extra mile, I go ahead and put another 2.5% non-voting. So now, even if that creditor could convince a judge that charging order rules shouldn't apply, the creditor's not going to get the voting control. My client's the manager of the LLC. My client has half the voting control. conceivably a creditor could get that, maybe if it was a California case and California doesn't recognize tenancy by the entireties or the law changes. Now, if the client is single, then to the extent the client would like to make a gift of LLC interest to an irrevocable trust that the client is not a beneficiary of, or to a slat where the client's spouse is a beneficiary, I'll put a material part of the LLC interest into that trust to have multiple members. And then the remaining percentage I'll put into TBE, or I'll give to the spouse who's lower risk, or we'll set up a Nevada or other asset protection trust to own the rest of it. We can't be sure that a Nevada trust would hold up for a Florida resident, but if the worst case scenario was that the judgment would, the judgment holder would only get a charging order, are they going to go all the way to Nevada, try to break up the trust? By the time they get to Nevada, by the time they get a judgment, this trust is going to be offshore. So, you know, these are the things we do. A lot of lawyers in creditor protection states ask what we do in Florida, and that's what we do. Okay, final question from Rebecca. Is there common law marriage or other imputed marriage for long-standing relationships in Florida? And the answer is no. Florida abolished common law marriage a long time ago. And palimony is very, very difficult to show. You would have to show it under contract law that for good and valuable consideration, spouse one, significant other one agreed that they would clean the house every day and drive the kids everywhere. And in exchange for that, they would receive half of spouse number two's money. That's a really hard thing to prove. So, but that would be a reason to have an agreement with your long-term significant other that you do not have a palimony situation. Palimony started with the Lee Marvin case, Leemarvin, in California. I think F. Lee Bailey was involved with it, and there was a hot tub involved somehow too. I don't remember exactly how that all worked. So in the remaining 7 minutes, I'm going to first quickly mention that a durable power of attorney signed by a Floridian in Florida after September of 2011 doesn't do what you expect it to do unless, number one, it's very lengthy, because you can't just say, I give my agent the authority to do anything on earth. That's what we used to be able to say. Now it needs to say, I give my agent the authority to sell my cat, sell my dog, drive my car, sell my house, get new shingles. The statute says it has to say specifically what the agent is allowed to do. I'll be glad to share our form, which runs about 50 pages when you print it on 12-point print. I developed it for a Bloomberg B&A program. Secondly, there are 6 items on that power of attorney that have no force or effect unless the client initials all 6 of them. And you can't just say, I initial here for all 6 of these. That won't work. So you go into any bookstore in Florida and buy a power of attorney guide, and it is wrong and it doesn't work. On our healthcare power of attorney, a relative cannot be a witness or a notary on the healthcare power of attorney. So we just get a lot of questions about that. I wanted to clear it up. Now, here is a typical Florida estate plan. Most Florida law firms are not using joint trusts for wealthy clients, even though nowadays we probably can. Our law firm does, but most often each spouse has their own separate revocable trust. On the death of that spouse, the surviving spouse is typically the trustee or co-trustee and can receive benefits as needed for health, education, maintenance, and support. And that trust of the first dying spouse is never subject to estate tax or creditor claims. So a separate revocable trust for each spouse. And then for added asset protection planning, a spousal limited access trust. Spouse one puts a big gift into the spousal limited access trust. Spouse two is the trustee and beneficiary. Creditors can't touch it. It's out of their estate for estate tax planning purposes. You can have a revocable trust that is a tenancy by the entireties trust, but Judge Jenneman, a well-respected bankruptcy judge in Orlando, has written two opinions. In both opinions, the trust did not qualify as a TBE trust because it did not follow the 6 unities. In particular, on the death of one spouse, it wasn't solely for the other spouse. But in Judge Jenneman's opinion, she says in Florida, you can't have a TBE revocable trust. Well, I disagree with her. I keep meaning to write her a letter, although I don't know that I want to get on her bad side in case any of my clients are ever in front of her with one of my estate plans. But anyway, so if you're going to set up a simple joint trust and you want TBE, put the client's assets into an LLC and then have a revocable trust like you normally would, and have a pay on death feature or a conditional assignment of ownership on the LLC so that it will automatically be owned by the trust on death. And if you want to put your homestead in that trust, that's probably fine, but just recognize that there's one bankruptcy court decision. The judge since then died, but what he said was homestead is not protected in a revocable trust. It's only protected in personal names. Now, since then, every commentator and every case has been to the contrary, but why take chances if your client is a neurosurgeon, high risk? Then you might want to just use the homestead in joint names with that ladybird deed. Now, the final thing is a lot of our clients do have the JESS Trust, the Joint Exempt Step-Up Trust. And with a Joint Exempt Step-Up Trust, you have joint ownership of the asset. Let me find my handy-dandy slide. You have joint ownership in a joint trust. And you know what? Spouse one could be a neurosurgeon and own 1% of the trust. Spouse two, a school teacher, owning 98% of the trust. But when spouse one dies, because of a power of appointment arrangement, all of the trust assets up to $12,060,000 can land in a trust for the benefit of spouse two that will never be subject to estate tax on the second death, and that will be protected from spouse two's eventual next spouse. So this is the JESS Trust is a very popular trust among people who have considered it and who understand it. And there's more information on the JESS Trust in our YouTube videos. Howard Zaritsky spoke about it at the Heckerling Institute in 2015, and I helped invent it, so I get to talk about it as often as I can. Finally, as I mentioned before, Florida does have a community property trust feature. You can form a Florida community property trust. You don't have to live in Florida to form the trust. You could appoint any Floridian to be your trustee. And on death, we believe and hope that you get a full step up in basis for all the assets in the trust. So you have a client they have 600,000 of assets. They paid 200,000 for them. When one spouse dies, you want a full step up, so there's no capital gains tax on the second death. You can use a Florida Community Property Trust, or you can use a JESS Trust. So those are really important for clients with modest means. They don't want to pay capital gains tax. That's what the article that Jonathan and I wrote that you have here is about. Okay, that completes my 1 hour. I will answer any further questions by email. We're going to take about a 1 or 2 minute break here, and or start right in, depending upon technology. and I'm going to be joined by Rhett Schweitzer, who's going to talk about yoga, physical therapy, and what the two professions should know about each other. And Rhett, are you here by chance?
I am.
Excellent.
I am here. Okay.
And I see your screen.
All right, let me find my, here we are. We got slideshow. Okay.
Okay, I want to give a little bit of background, Rhett.
Sure.
Rhett and I have known each other a long, long time, and I have gone to Rhett for physical therapy. And he is a real, a professional who cares and is interested in what he's doing and who goes the extra mile, which I have been able to see from other patients of Rhett. This is somebody who you want to use as a professional. So Rhett, tell us a little bit about yourself and then launch into your program. I know everybody is excited to see it.
Sure. Thank you, Alan. I've been a physical therapist for 20 years and have used yoga for much of that time. Certified yoga teacher now, also a professor in physical therapy. And I also travel the country teaching continuing education to physical therapists and yoga instructors so that these two professions can borrow ideas from each other for better outcomes.
I think we need your camera on.
Oh, okay. All right, there we go.
All right, super. Take it away.
All right. All right. Well, thank you for the time, everyone, and your attention. I promise this talk will be more exciting than watching Florida Turtles race. As Alan had me already say, I'm Rhett Schweitzer, a board certified physical therapist and yoga teacher. And as I mentioned, I teach these two professions on how to share ideas so that we can improve clinical outcomes. And I would like to go to the next slide, and I need to know how to do that.
Probably an arrow button, or you scroll down.
There we go. Okay, let's start off with a joke. Why did the yoga teacher get fired from her cashier job? Because she kept saying change comes from within. All right. I imagine if everyone had their speaker on, it'd be just incredible laughter right now. All right. As I mentioned, this is who I am. I teach physical therapy. I've authored 4 textbook chapters in physical therapy, and I teach coursework to PTs about yoga and yoga teachers about physical therapy. So despite my training of these professions, this webinar is for everybody or anybody who has a body. All right. And if I could see you, I'd say raise your hand if you have a body. Since it's a webinar, I can't tell, but I'm imagining everybody does. So this is important for everybody, regardless of whether you're a PT or into yoga. And from now on, I will say physical therapy or PT, but I'm referring to physical therapy and occupational therapy as they're very similar and they can both benefit from adding yoga into the picture. And there's chances are that you'll experience PT in your lifetime, and many of you probably already use yoga. There's about 40,000 PT clinics in the US. That translates to upwards of 300 million treatments a year. And meanwhile, as of 2016, about 30 million people report using yoga, which makes it the most commonly used complementary health approach in the United States. And as I will show, you stand to receive objectively improved care if your PT or OT uses yoga in treatment. And your yoga teacher provides a safer, more therapeutic environment with some PT knowledge. All right, so this is the goal: better outcomes through sharing between therapy and yoga. Now, the goal of my webinar here is to teach how blending these two profession strategies will lead to better healthcare and safer yoga. And for this to translate to you and your needs, in the event that you need PT or you currently attend yoga, you have to want to appreciate how this symbiotic relationship should and could exist. So if you're committed to learning all the ways that PT and yoga can benefit each other, ultimately for your benefit as a client or a patient, then again, raise your hand even if I can't see you, right? So we're all in. All right. Here's our game plan. We're going to lay out the current problem with the divide in knowledge of these two professions. We'll explain how sharing some knowledge will benefit both clients and patients. I say patients for physical therapy and clients for yoga. And I'll tell you what you can do as a PT patient or a yoga client to help this union to ultimately give you better outcomes. So the first question is, why is there such a strict division of different healthcare fields, and why is this a problem? There's always been divisions within healthcare professions due to a multitude of reasons, but mostly, I believe, due to the capitalistic nature of our healthcare system. Certain professions fight hard in court to restrict others' abilities to provide crossover services that they themselves want to own as their own. And this is ultimately a detriment to patients' health and to their wallet. So it's very clear, and the research supports this, when professions share knowledge and strategies, the winner is 100% the patient. And there's many, many examples of this. Frequently in medical research, we try to study things in a vacuum where we'll do one treatment, one intervention. And we find when we combine it with any other intervention, success goes up. So a lot of studies are limited because they're studying one intervention. But anytime we add in another strategy, the outcomes go up. For example, surgery is more effective when physical therapy follows it. Chiropractic is effective, but it's more effective when exercise is blended in. I mean, I could go on, but combining. We have not studied yoga and physical therapy combined, but if we did, we'd find they'd be more successful than each intervention on its own. So let's get more specific. How will the actual sharing of knowledge between PT and yoga help you as a patient? All right, first, before we go into the slide that I just went to, let me see if I can go back. No, I'm not going to go back. All right, we're going to get to this slide. But first, before we get to this slide, for those of you who have been in therapy, have been to physical therapy, I want you to think about how effective you thought it was on a scale from 1 to 10, 1 being not very effective and 10 being very effective. And generally, patients are generally quite happy with physical therapy. So I would imagine that most of you would have rated that at a higher number, closer up to 10. And same thing with yoga. I mean, people are choosing to go to yoga. They're not necessarily going there like with physical therapy due to an injury, although some are. But generally, people also would rate yoga as very happy. But there is some not good news. Despite the success you may have had with physical therapy, it turns out that no matter who you go to in healthcare, MD, chiropractic, acupuncturist, massage therapist, reoccurrence of the same original pain is extremely common. For example, shoulder pain reoccurrence is about 50%, and back pain returns about 84% of the time within 1 year, no matter who you go to. And my citations for those numbers are listed there. So maybe some or all of you have experienced this incomplete healing. I even personally have. So PTs and OTs and all healthcare, all medicine should ask this very humbling question. how can we increase outcomes and make people better in the long term? That's a tough question. We don't ask it enough. And what I'll tell you the answer is not, is boring home exercises. That is a elephant seal yawning all the way down at the South Pole because he's so bored by your home exercises that your PT gave you. You've all received those pieces of paper with bad drawings as pictured on the left here. I know because I have personally been drawing them poorly since 1999. Home exercise programs have a horrible compliance rate with non-adherence to home exercises at about 50 to 70%, according to 2018 study. So put another way, people don't like home exercises, and that's out of the gate. So you follow them up 6 months to a year, and 0 people, 0% practically, close to it, are doing their home exercises. So yoga is a solution to long-term healing by getting patients hooked on ongoing exercise that moves the body, moves the breath, and calms the mind. So yoga does far more than home exercises, not only being more interesting and increasing compliance, but it also addresses more than just these isolated single movements that home exercises tend to do. Now, there's also some not ideal news for the yoga teacher. Yoga teachers will be asked to come to the aid of injured people, and yoga teacher training does not prepare them for this role. So yoga does cause more injuries than one would expect. According to a 2017 study, yoga causes musculoskeletal pain, that's MSK, that's joints, bones, ligaments, tendons, muscles. About 10% of people who participate, and increases or exacerbates 21% of existing injuries. So that's pretty significant. In addition, many people actually go to yoga because of an injury. So both PTs and MDs are much more commonly referring patients to yoga with injuries, according to a 2007 study. So since that study, it's become much more prevalent. But again, yoga teacher training doesn't talk about injury, specifically musculoskeletal injury. So this means to be of best service to clients, yoga teachers need to understand basic physical therapy principles, including how to heal injuries. So we have the motivation and the justification for both professions to employ each other's knowledge. Okay, that sounds great. So I've convinced you that you want your PT to know yoga and you want your yoga teacher to know PT, but what can you do about it? So that's why I do what I do. I teach a 2-day course around the country to PTs and OTs on how to use yoga in their treatments. I'm not teaching them to be yoga teachers, but I'm teaching them to borrow really, really critical ideas from yoga, not just asanas, which are the positions we do in yoga, but also how to assess breathing and how to bring mindfulness to patients, which are both evidence-based. That means there's research backing these strategies for improving healing, and PTs do not use them. Rarely do PTs use the breath or mindfulness. So if you have a line to your PT and OT, then don't hesitate to tell them about this course. It's a very unique course. This is rarely taught. You can find some online courses, but not live. And I think live teaching is really important, especially in a field where we're touching patients. And I'll get them to use yoga effectively by the time you see them again. And on the other hand, basically nobody, I can say basically nobody, is teaching physical therapy principles to yoga teachers. So I can assure you that your teacher would benefit from a course that I offer to that profession. And again, I believe it's because of this division that we have in the healthcare / fitness world, for, again, a multitude of reasons, but probably a little bit of ego and ownership is involved. And I don't believe in either of those. I believe in getting improved outcomes in our patients and clients and keeping people safe and healthy. So the course for yoga teachers is an 8-hour live course titled Physical Therapy 101 for the yoga teacher. And we cover how to effectively help heal orthopedic injuries using yoga. So basic ideas and concepts that they completely understand. They've got the anatomy background to appreciate what I'm talking about. And we cover neck and shoulder, back, knee, and ankle pain, which are the 5 most common musculoskeletal injuries in our population. And I've offered this course already, and feedback I'm getting from yoga teachers about the course has been fantastic. So I'm really, really excited about it. So my website is yogatherapyseminars.com, and I also will be available. I'm maybe through email, I'm not sure how, but I'm more than willing to answer any questions that anybody has. I like talking about this, kind of nerd out about it. And that's the, of course, if anybody wants any of my resources, email me. I'm always willing to share literature. Or if you have a question about physical therapy or yoga that I didn't talk about, please ask, and I can also probably share literature on that topic too.
So Eric, we got.
Yeah.
Oh, I'm sorry. Go ahead. Go ahead. Okay. What is what's a common symptom or situation that a yoga teacher would not spot and would cause some harm, where the teacher should say, wait a minute, if you have this, go to a PT or a doctor first?
That's a great question. Really good question, because that's essentially what I want to teach them. In that course, I talk a lot about when to refer. And what I also teach them is that many times you don't have to refer, because they can get nervous. Someone has pain and they get nervous. So I help them categorize pain. So to answer your question, if pain is acute, so it's really sharp, doesn't mean that there's something bad happening. Honestly, it's weird. Our body is weird. But if we have really sharp pain, it doesn't mean it's serious, but best to send it to somebody to evaluate it. So if 0 is no pain, 10 is excruciating, if it's over a 6, I teach the yoga teacher, let's get someone else on the team to just make sure it's nothing. Again, it's probably nothing. Most of the time, musculoskeletal pain is simply bones, muscles, ligaments, tendons, and those things heal really well with yoga. But in rare cases, it indicates something more serious, that you need a good diagnostician to assess. And both physical therapists and MDs have proven in literature to be very good diagnosticians of non-musculoskeletal pain coming from tissues other than the musculoskeletal system. So that's one example. Another example might be a person who might be osteoporotic. There's ways to ask certain questions. A lot of this is through just a couple questions, and that might be someone who you would definitely encourage sending on to someone to evaluate their safety in yoga. But these are rare cases.
What are the two questions?
I'm sorry. Oh, for osteoporosis?
Uh-huh.
A history of fractures. That's a very important question, because if someone has a history of fractures, then they're more likely to be osteoporotic. And then it's not a slam dunk, but we can use age as a little bit of a measure. But again, that's not, to keep it simple, that's probably what I would narrow it down to 2. But there are other questions, but they would go beyond the yoga teacher's skill. So age and history of fractures is the 2 questions.
So Eric, let me put you on the spot here and hope for some candor. If you had back pain and you were like, oh my gosh, I have back pain, I've never had this pain before, I think I better go see somebody, would you personally go to, and if you know nothing, would you go to a physical therapist, a chiropractor, a yoga practitioner? The answer to that is no. an MD, or an osteopath? And what would you expect from each?
That's a great question, and I like that question because it gets me a chance to step out of my worldview and ask truly, what would I do? And the evidence suggests that it really doesn't matter. It really doesn't. And that doesn't mean that there isn't a truth out there, right? Because research is always developing. But as of today, we do not have enough evidence to suggest one practitioner is better than the rest. I don't know about 5 or 10 years from now, but we don't at this point. The one group that it goes at the end of the line, the very, very, very end of the line, is the surgeon. We have enough evidence to suggest that we do not need to be talking to a surgeon until we have tried all conservative treatments, because the outcomes for back surgery are poor, and that's just fact. So it doesn't mean it's off the table, but you definitely have to exhaust treatments that do not have such a large downside before you go there. But other than that, it doesn't matter. And if you're not in this small number of people who have a hidden disease causing the pain, in back pain, it's about 1.8%. So it's not non-existent. That means 1.8% of people who have back pain, it's coming from more treacherous things like cancer or tumor or infection, among other things. But so that those people, if you're not in that group, then you could go to yoga. And there are some indications of whether you're in that group, and that's what I teach yoga teachers. There are things to look for, and don't get me wrong, even when you go to a PT or MD, they miss it too sometimes, because sometimes it's not black and white, but sometimes it is. And there's a couple things that the yoga teacher can look for to see if you're in that small percentage. But if you aren't, yoga has been found to be incredibly effective, in some cases as effective as physical therapy, at reducing back pain.
Eric, talk about if you want to know what's going on in there, you get an X-ray or you get an MRI, and then sometimes the MRI you would think you'd be crippled, but you don't feel anything and you're absolutely fine. Sometimes the MRI, it looks normal, but you have a lot of pain. What is the human experience there? What's the wisdom?
Yeah, it's a great question. So over and over again, we have established that X-rays should not be performed except for when there are red flags, which are those few things that tell us maybe you're in that small percentage of bigger problems. So all groups are on board. American Academy of Family Physicians say do not X-ray people unless they have those red flags or they've had the pain for a minimum of 6 weeks, minimum. Same with MRI. And the problem with doing these films is that when we do these films on people who have no pain, we find problems that should be giving them pain. That's well established. So when someone comes in hurting and we do an X-ray or an MRI, we tend to tell them information that might not be related to their pain. So because the asymptomatic population has the same X-rays and the same MRIs. So this is a tool that's very useful in many cases, but it needs to be wielded carefully. And your best bet is to treat it conservatively. Yoga, PT, chiro, acupuncture, a combination of all or any is fine and encouraged. And then if pain doesn't go away in no less than 6 weeks, but maybe even a little longer if it's trending toward better, because some pain sticks around for 8 weeks, 12 weeks, then you probably won't need the X-ray or MRI. You save yourself money, you save yourself the stress of knowing that you are slowly degenerating because you're a human fighting gravity, and your life goes on. That's the recommendation. And that's not just my recommendation, that's the research's recommendation.
Right. So Eric, if I want to go to yoga, what sort of certification do I need to make sure my yoga instructor has? Or is it a mixed bag? Seems like it's just like anyone can be an accountant. You just get an occupational license and put the word accountant on it. You're an
Yeah.
accountant. How does it work for yoga?
Yeah, in a lot of states, yoga is unregulated, and therefore you don't need a certification or training. So knowing maybe that they went to a yoga teacher training would be reasonable. I think if you go to a formal class, most have gone to yoga teacher training, but it's not required. So that's a 200-hour certification, and it gives the basis for flowing through yoga with asana poses. So they don't get any, and there's some anatomy too, but there's not any training on healing. There's a small subsection of yoga teachers that go on to 800 hours of training, and they call themselves yoga therapists. They're very rare. There's about 3,000 compared to 100,000 yoga teachers. And their training goes a little bit more into emotional healing. They do cover some physical healing, but they're not physical therapists in any way, shape, or form. So there's two. So, but they do have more knowledge, and like I say, it's a lot of more holistic healing, talking about stress and emotional and mental support. I think they're a little more into psychology than physical healing. I'm not a therapist, so I'm not an expert in what they do.
What about a Pilates instructor?
Yeah, I mean, Pilates is great. And Pilates has more intertwining to physical therapy. So there is Pilates certifications for physical therapists. There is not for yoga, not well known. So Pilates and physical therapy have blended ahead of what I'm doing here with yoga and physical therapy. And Pilates is great. And I've done it myself. I'm not trained in it or certified in it. But it's another angle to attack pain that is completely acceptable. If you found your Pilates instructor was also a physical therapist, that would be awesome. And you can find that. That's probably more common than your yoga teacher being a physical therapist.
Okay, that's great. I mean, my own story and stories of others, I went to a doctor with back pain and he said, well, you're going to go get an injection. So I went to a neurologist client of mine and said, I'm here to get my injection because my back hurts. And he looked at me with a face of amazement and he said, Alan, before I put a needle in your spine, you need to go try yoga, Pilates, acupuncture, witchcraft, try everything before you ever let someone like me put a needle in your spine. So yeah, that's when I went to you, Rhett, and said, what do I do? And you showed me very simple exercises that no one had ever showed me before. Well, lie on your back and pedal your legs and stretch this and stretch that. And then I went and took Pilates and it all went away. I never needed a needle in my back.
No, not at all. And the needles have a very low success rate. So that's a smart physician who's up on his knowledge and research and realizes that you will get better if you work it out and if you stay positive, which is why I'm teaching mindfulness to physical therapists, so we can keep working on the biopsychosocial model of healing, not just biomedical. We used to do biomedical, meaning you have a tissue, it has a problem, we need to do something to it, inject it, cut it, repair it. And it thought of people as just a tissue. And this goes back to an author from, I want to say, the early 70s, MD Engel was his name, and he came up with the idea that we need to treat people on more of a biopsychosocial form of healing. Biology is still important, but we've got psychology and sociology involved. And what we can take from that is we need to keep people positive and not scare them with tales of them breaking down inside, which is why the MRI is so destructive sometimes to people's healing. because it makes you feel broken. And when you feel broken, your morale drops. And this all is anti-healing because it's ignoring the psychological part of healing. So staying positive, staying active, and knowing that you're going to get better is one thing. That's one thing I teach yoga teachers that they wouldn't know otherwise. If someone has pain, teach them that they're going to be better within 2 months. Just tell them they're going to be better within 2 months, because if they put their mind there, then they're likely, the odds are so much in their favor that they're going to go in that direction.
Wow. That's great advice.
Yeah, my pleasure.
Yeah, Eric, thank you very much for sharing that. Any final words that you want to? Oh, I have another question. What book would a layman read if a layman has back issues, and we all have deteriorating discs, and this hurts and that hurts? What one thing would I be able to sit down and read for an hour to understand more about what's going on in my back or in my shoulder or in my neck?
I just read for the second time a really good book, and it's all on the psychology of healing. And it's called You Are the Placebo by Di Giovanni. If you type in You Are the Placebo book, it will come up because it was very popular. And it's a fantastic book that shows how much of our healing is in our mind. And not that we're making up pain, pain's real, but we can steer pain through beliefs and through expectations and through avoiding negativity. And it's really, I mean, honestly, it's besides staying active in some way that you can stay active. That's the extent. It's okay to go to somebody and get their advice as long as their advice is congruent with stay active, keep moving. There are things that practitioners, PTs, chiros, acupuncturists, they can do to help lower the pain immediately. But the long-term solution is to stay active, which is why yoga is great, because you get addicted and you keep going. But we need to get our mind in the right place, and You Are the Placebo is a fantastic book at appreciating how powerful the mind is when it comes to healing.
Now, all right, well, if anyone has any questions for Eric beyond what I've read, just send me an email. I'll be glad to forward it, or Rhett, do you want to give your email address, or do you have it there?
Sure. Yeah. My birth name is Eric, so my email address is Eric, and last name is Schweitzer, SCHWEITZER. Eric Schweitzer 75@gmail.com. That's my personal email.
Beautiful.
And I'm happy to answer questions.
Great. Okay, everybody. I hope you've had a nice experience with this presentation. I know I've enjoyed it, and I've heard some things that are going to help both me and some family members. Rhett, thanks again for joining us.
My pleasure.
We'll see everybody next Saturday at 11 a.m. Eastern Standard Time, if you can stand even more of this. Thank you very much.